Good morning, everyone. Welcome to the Mason Hayes & Curran webinar on regulatory investigations and prosecutions. My name is Shane Reynolds. I'm a partner on our health and prosecutions team. I previously worked for a leading criminal defence firm for 10 years before joining Mason Hayes & Curran in 2013. Our team advises state bodies in the area of regulatory prosecutions and also advise corporates in the area of investigations and white-collar crime. I will be chairing this morning's webinar, and I'm delighted to be joined by two speakers. Firstly, Fiona McNulty is a senior associate on our health and prosecutions team. Fiona previously was the instructing solicitor in a number of jury trials in the circuit and central criminal courts. Fiona currently prosecutes cases in diverse areas such as environmental law, energy, public health, and food hygiene. I'm delighted to be joined by Aisling Kelly, who is Assistant General Counsel at Microsoft, leading their law enforcement and national security team in the EU. The team deals with lawful demands such as warrants, production orders for electronic evidence from police and intelligence agencies. Aisling formerly prosecuted with the Director of Public Prosecutions in Ireland and the United Nations International Criminal Tribunal for Rwanda. Aisling originally qualified as a solicitor in 2002 and transferred to the bar in 2015. So this morning we will be discussing search warrants and production orders in criminal and regulatory investigations from the viewpoint of both investigators and also corporates who may be in receipt of such search warrants and orders. Secondly, Aisling will give an insight into recent developments, international and EU developments in the area of electronic evidence, and also discuss the challenge of managing this type of data. So we're going to chat for about 40 minutes and followed by Q&A for about 10 minutes. There's a chat function at the on your screen, so as we go along, feel free to insert questions into that function. So firstly, Fiona, if I can come to you, I think it's always helpful to return to first principles in this area and provide maybe an overview, if you wouldn't mind, of the domestic situation as it currently stands in respect of search warrants and production orders, please.
Yes, thanks, Shane, and good morning to everyone on the call. I am going to speak about domestic warrants for the next 15 minutes or so. So firstly, what are the most common documents that you're likely to face when you're looking at warrants? I'm going to touch on mutual legal assistance and also look at some practice and procedure around executing warrants. I'll also look at a Supreme Court decision on search warrants, and then I think, Shane, at the end we will look at some practical tips for both investigators and those on the receiving end of warrants. So when we're talking about warrants themselves, there's what a warrant is. It's a written legal order that gives powers to an investigator, and there's two categories, as you've identified. There's search warrants and there's production orders. Most often, search warrants and production orders are issued by a district court judge based on information provided to him or her. Search warrant allows the investigator to enter the property and typically confers additional powers. So, for example, to inspect, to examine, to search, or to seize in the context of an ongoing criminal investigation. The investigator would have a lot of control in the case of a search warrant. So I could give you the extreme example of a dawn raid where the investigator lands in unannounced to a property or premises and they will conduct that search. I think it's fair to say, Shane, in practice that we see it's not always as dramatic as that. So maybe technology or social media companies who hold a lot of user data, they might very often see a search warrant under Section 10 of the Criminal Justice Act 1997, where the Gardaí would be seeking data, and in those types of cases, the Gardaí don't even always exercise their power of entry. They simply will send over the request, which would be dealt with without the investigator ever having, again, exercised that power of investigation. In terms of production orders, the production order just compels an individual or a company in possession of materials to produce those materials. We would see in practice that production orders are more often narrower in scope. they don't grant that power of entry on the investigator, and they would often specify a period of time within which the company or individual named in the production order has the time they have to comply with the order. I think something that's really important, Shane, for investigators who aren't on Garda Síochána to be aware of is that there's a whole host of legislative provisions under Irish law for search warrants, and they'll each have their own specific provisions and conditions. So, for example, what is required of the person who's issuing the warrant? Does the district court judge or senior Garda have to have a reasonable belief, or is it a reasonable suspicion? Another example would be Gas Networks Ireland. In order for them to obtain a search warrant, they need to first establish that they've been prevented from entering the property unless it's a private dwelling, or you might have search warrants that extend to search of persons present on the property. They're all just examples, but it underlines the fact that there's no one size fits all type of warrant in Ireland. If you're in doubt, go back to the legislative provision that's relevant to your statutory authority. And it does go without saying, compliance with a valid court order, it's not optional. It's typically an offence not to comply with the search warrant or the production order. So whether it's a search warrant or a production order, you're going to be taking it seriously. Mutual legal assistance is something that you might see coming up from time to time, and that mutual legal assistance itself, it's how states cooperate and assist one another in criminal investigations in their respective jurisdictions. In Ireland, the Minister for Justice is the central authority, and the Minister would receive a wide variety of requests for mutual legal assistance, such as maybe providing DNA evidence that they might hold on a register or something like that. In the warrants context, you'd be looking specifically at Section 74 and 75 of the Criminal Justice Mutual Assistance Act 2008. Section 74 is search warrants, Section 75 is production orders, and it will be either on Garda Síochána or the Revenue Commissioners who can obtain these orders from the district court. And I think, again, if you're working in an organization or a company that holds a lot of user data or records, whether it's a social media company or a financial institution, you might be likely to see these types of warrants cross your desk from time to time. For investigators who are executing search warrants, I think there's a couple of things to bear in mind, and you're obviously going to want to plan this out in advance. Consider what your plan of action is. Does your warrant authorise on Garda Síochána to accompany you on the execution of the warrant? Will you need backup? Who from your team is going to attend? You're going to consider, are you going to do it in a surprise dawn raid style? Is it going to be pre-arranged search warrant? You'll be bringing the warrant itself and certified copies. While some provisions would expressly provide for the occupier or owner of the property to be shown a copy of the warrant, I think that there's no reason why you wouldn't be providing a copy to the owner occupier unless there's some exceptional circumstance, like maybe if there's a potential endangerment of the authorised officer or something like that. When it comes to the use of force, it's usually provided for in the warrant again, but it would have to be reasonable. When you arrive to execute the warrant, you're going to introduce yourself, explain your title, your authority to conduct the search. If there isn't cooperation with the search warrant, I've referenced the fact that that is an offence, but if you find that there is non-compliance by whoever you encounter when executing your search warrant, you're going to want to issue the caution. So for example, under Section X of whatever act, it's an offence not to refuse to comply, and if you're convicted, the penalty is such and such. If you are going to be possibly seizing physical items in the search, you might want to ensure that you have evidence bags for that purpose, or if you're going to be dealing with a lot of electronic data, what are the practicalities of how you're going to gather that? When it comes to a search warrant it's not an ongoing power of entry that's granted to an investigator, so you would typically approach it on the basis you would approach it on the basis that it's a single execution. And if you have some kind of problem or issue when you're trying to execute the warrant, and you might want to consider if you can't complete the execution at that point, our advice would be that you would apply for a fresh warrant, that it's not you can keep going. The search itself, so I suppose the terms of a search warrant would need to be proportionate. I'm conscious that there are regulatory investigators and prosecutors on the webinar today who will have a duty to act reasonably and act proportionately in the course of their investigation. And an excessive seizure of material when you're executing a search warrant, that will be open to challenge. And I think there's a very good example of what an excessive seizure might look like from a 2017 Supreme Court case, which is one that investigators dealing with warrants should be aware of. The title of the case is CRC PLC, Irish Cement Limited and others, and the Competition and Consumer Protection Commission, that's the CPCC. And generally speaking, the CPCC has very broad powers under the Competition and Consumer Protection Act 2014 to obtain warrants to enter premises and seize materials. And very often you might see the CPCC involved in a dawn raid style search warrant. What happened in this particular case was that the CPCC were investigating alleged anti-competitive practices at Irish Cement Limited, and Irish Cement Limited had a parent group, CRC. The CPCC conducted a search in May 2015 on foot of a search warrant, and among the materials that they seized was an entire email account of a former managing director of the subsidiary group Irish Cement Limited. But he had since gone on to become a managing director in the parent company. So both Irish Cement Limited and the parent company challenged the seizure of the entirety of the email account. They argued that the email account contained a huge amount of information, but that only a portion of it would have related to the activities of Irish Cement Limited, which was the organisation under investigation and the organisation named in the warrant. The High Court agreed with them. They found that the CPC had seized information that was outside the scope of the warrant, and on appeal to the Supreme Court also agreed with that position. They dismissed the appeal by the CPCC. They found that the investigator here had acted outside of its powers, not only in breach of the constitutional rights of the companies under Irish law, but that it also amounted to a breach of their privacy rights under European law. The Supreme Court did acknowledge that there may be some exceptional circumstances where it's not possible to have a neatly defined scope, but I think overall it was critical of the broad scope of the warrant relied on in this case, and it pointed to some practical steps that investigators could take. So for example, it was electronic information, in this case an email account. They pointed to the fact that you can utilize keyword searches to narrow the scope. So again, Shane, I think it just really highlights the need for the information sought in a warrant to be as precisely defined as possible.
Thanks, Fiona. I think it's always helpful to return to, as I say, an overview and a revision of the current landscape for warrants and production orders in Ireland. And I just ask, in respect of for investigators on the webinar this morning, and any practical tips in terms of the drafting of the warrants and orders. I know the district court rules will obviously provide a template for a lot of the warrants and also the information, which the information is the actual application for the warrant. But I think there are some warrants powers under the statutory provisions which will apply to certain investigators that there's no templates for them. But have you any practical tips in respect of the actual drafting of the orders or warrants?
Yeah, well, two things are absolutely essential. The first is the warrant has to clearly state the powers that are conferred by virtue of that court order, and it should also refer to the relevant statutory provision. I think some common pitfalls for warrants would be if the warrant is too vague, if it's not specific enough, if there's a property, is the property adequately identified? So using the very precise address, air code, if you can get it. as you said, there's a lot of warrants that have templates available, whether they're internal templates that your organization have used before, or if they're from the district court rules. But it's important to be aware that you need to delete the pro forma part. So where there's X/Y/Z, make sure that you're deleting the parts that don't apply. You need to identify who has issued the warrant. Is it a district court judge? If it's a senior member of An Garda Síochána or Peace Commissioner. Very obvious mistake, but it does arise, is make sure that the warrant or the order is correctly dated and that the dates are all, that there's nothing copied over. There are just some of the issues that can arise, Shane, but as you know, there's a huge body of case law on the validity of warrants in Ireland, and really in each case where there's some defect identified, it's just going to come down to an analysis of the facts in each particular case. Since the JC Supreme Court decision, we've very much seen in Ireland a move away from the exclusionary rule. So the courts will be looking at the bigger picture and engaging on a balancing exercise in each case.
Yeah, and I think the Law Reform Commission in their previous consultation paper on this were very critical in terms of obviously the number of prescribed forms and district court rules, and that their recommendation is that they should be replaced by a generic application. But here and now we are where we are, and unfortunately for investigators, it's finding the correct, obviously, warrant and template for their application. Can I just ask you then, just in terms of, I know there's people on the call that are in corporates who may be in receipt of these warrants or production orders, and again, we see this quite regularly where we receive warrants in, and we were asked for advice. Is there any grounds to push back on law enforcement in respect of such orders? And again, do you have any top tips there for companies to push back on such orders if they feel the order may not be valid?
Yes, and obviously those that can be a difficult position to be in, because you have an obligation to comply with a valid court order, but you're also responsible for holding very sensitive data, maybe in relation to your service user, your client, or your customer. So you firstly need to review the document that you're presented with very carefully. You might want to seek legal advice if you're not familiar with it. I know that when we're advising on warrants or production orders, some things that we're looking at is what's the legal basis for the warrant. So what is that specific statutory provision that gives power to the investigator? Is the warrant signed? Is it dated? Who has issued the warrant? Again, it's mostly district court judges issue warrants, but there are some limited provisions for senior members of An Garda Síochána or Peace Commissioners to do so. So checking that. What is authorised in the warrant? Is it a search warrant? Is it a production order? If it's a production order, what's the time frame for compliance with it? Is the information that's sought, is it sufficiently clearly identified? If there's a request for bank statements for John Murphy, is that really going to be enough, or should there be John Murphy's address or account number and so on? I think if your organisation is likely to continually receive warrants or production orders, then you definitely should be having some kind of a system in place so that there's a process to be followed when the warrants come in.
Thanks, Joe. I think that's very helpful practical advice for corporates who may be in receipt of these orders. Thanks, Fiona. If I could just turn to Aisling then. Aisling, I know you've had a look at the, and it's obviously in your area of practice, the EU legislation, which is a very topical issue on electronic evidence. Can I firstly ask you, Aisling, just, I suppose overall, what's the overall aim of this new legislation?
It's really to improve cross-border cooperation in criminal investigations right throughout the EU. There's currently no harmonising system to obtain electronic evidence. So if you're a police agency here in Ireland or you're a police agency in Italy, it differs depending on the country or the service provider that you're dealing with. So in order to basically harmonise the law, they're introducing these two new instruments, they're a massive fundamental change to how we're going to deal with electronic evidence going forward. And it's really akin to, the seismic change that European arrest warrants brought in, back in 2002.
Thanks, Ashley. So I think you've looked at this, obviously, and if you can just outline, I suppose, I think you've looked at from the point of view of private entities and what data and so forth. So look forward to hearing your views on it now.
Thanks, Shane. It's an area that I've actually been following very closely since before I worked with Microsoft being a prosecutor. And these two instruments, one is the regulation on European production and preservation orders for electronic evidence in criminal proceedings. And the second is a directive for the appointment of a legal representative for the purpose of gathering evidence in criminal proceedings. These two legal instruments have been on the boil now since 2018. The Commission put forward a proposal. They were actually born out of concern in Brussels from the terrorist attacks in 2016, and they're specifically mentioned in the recitals because law enforcement were having increasingly a difficult time prosecuting, investigating crime, which was happening cross-border and where the evidence was located outside the jurisdiction. So that's really, where we're coming from. We all know, obviously, that there's an existing system in order to obtain cross-border evidence, which is mutual legal assistance requests. But if anyone has had experience on the line with those MLATs, they're long, they're difficult. Sometimes they're sent to different countries. You may or may not get a response. So this, as I said, this regulation, which is expected to be finalised in early 2023, is to introduce a system where the law enforcement agency issues a preservation or production order. And the preservation order must be dealt with in a certain time frame. The production order has a 10-day turnaround time or 8 hours in an emergency request. And I said the preservation period is basically for 60 days with an extension of 30 days. So it's a much shorter condensed time frame that we're talking about here. And really the main seismic change in this type of legislation is really by cutting out the middleman. So with MLAT requests, you have them going to a central authority in the Department of Justice, and Fiona has mentioned that, the Irish Department of Justice fulfills that criteria in Ireland, and it's the same all over Europe. But this will allow law enforcement, whether that's a police agency or a regulator or an intelligence service, to go directly to the service provider. And that will basically speed up matters hugely. So the central authority still has a role. Each central authority in each member state still has a role because they will be notified depending on the type of data which is requested. And I suppose just to kind of clarify who is covered by this regulation, it covers electronic communication service providers and information service society providers. So lots of people on the line who are criminal lawyers may not really understand what those concepts are, and they're certainly concepts which I've become more familiar with having worked with Microsoft. It's basically any entity which offers communication services or data processing or storage. So examples would include email services, online marketplaces, which are huge, gaming platforms, gambling platforms, obviously cloud service providers, domain name registrars, and proxy service providers. So anyone, again, kind of basically with data storage. There are particular exemptions or exclusions which are expressly mentioned, and that's legal or architectural or accounting services, because the rationale here is that even though they store the data, they only communicate for the purposes of providing the service. The communication part is not the essential part. So that's really the key test. And then what type of data is covered by this regulation? It's subscriber data, so your registration, your IP address at creation, perhaps your billing address, and traffic data, obviously IP logs, which would establish where you're either logging on from or what you're logging to, and then content data, which is really obviously the highest tier of type of data that you can obtain and attracts the highest level of protection. Those terms are to be aligned with the definitions contained in the existing Budapest Convention on Cybercrime, which is a Council of Europe convention, which we can speak about a little bit later. And last year in May 2022, that particular convention spawned a second additional protocol on enhanced cooperation and disclosure of electronic evidence, and that's available on the Council of Europe website. And I'm going to send out with Carolina's help some web links to some of this material so you can have a look later on. These obviously, as I said, this type of data is of principal interest to law enforcement agencies to either commence or further criminal investigations. And then I think really just kind of briefly explain what the jurisdiction is here. Again, with MLATs or other types of cross-border cooperation, sometimes it's difficult to understand where the jurisdiction is based. The regulation makes it very, very clear here that if the service provider or communication service offers services to a legal or natural person in the EU, then they are on the hook. They're basically caught within the jurisdiction of the regulation. And so for it just as well, just to make sure that people are aware, if you're offering services, it's more than just a website. You have to enable the person to use your services. And there's also a minimum threshold for the type of criminal offences or investigations that we're talking about here. It would have to attract a 3-year minimum sentence, which is basically in line with lots of European countries. And obviously in Ireland, we have an arrestable offence minimum of 5 years. Interestingly, again, this is a major departure in terms of cross-border cooperation. This is an instrument which is not just going to be used by law enforcement agencies. There's a right under the regulation for defendants or their lawyers to use these preservation and production orders, which is really novel in criminal justice and really novel in EU criminal justice. So that's just, I suppose, some of the kind of the headline pieces of information about this regulation. And as I said, the central authority still has a role in this. Notice to users that law enforcement has requested their data is highly important, because if you think about it, someone knocks on your door with a search warrant, you know that the police are at your door or a regulator's at your door. Whereas if a production order is served on a service provider, you may not know about this. So there are obligations set out in the regulation for the central authority to actually notify people where police agencies or regulators have sought content data. And there's still a little bit of negotiation to finalise as to what that notification will look like and who they'll be notifying, but that's something to flag for another day. Obviously, I suppose this is a massive area where criminal law and data protection collide. So for people who are, either investigators or traditional law enforcement, data protection and privacy rights are something which probably are not embedded in their practice, but it's something to be highly aware of, that this is really something which is important, because as Fiona alluded to, we already have the Supreme Court judgment in CRH where privacy rights has been embedded in constitutional protections with these types of search warrants, and it's really important to be aware that the regulation, the draft regulation, bakes this type of protection in. So as early as recital 2, privacy rights are alluded to, and it's referenced right throughout the course of the regulation. There are some, I suppose, issues there in terms of who owns the data. So if you're talking about most service providers, their terms of service will make it clear that if you're using a service for free, that they are the data controllers and the data processors. Whereas if you are what they call an enterprise customer, so if you are a government department or a private industry, you are the data controller of your own data. And so there's a concept within the regulation that would say that law enforcement should look to distinguish between these two concepts. And that's what I mean about, I suppose, starting to upskill in terms of data protection concepts, because if you are a regulator on this call, you will need to know if the target of your investigation is the data controller of that data, and therefore you should properly go and serve that order on the data controller. And there's a couple of kind of international rules which have been, I suppose, thought out by jurisdictions who are perhaps further down the road than we are. The US Department of Justice and the UK Home Office have published guidelines in relation to this particular point about who you go to actually obtain the data. And again, we can provide links to that. So obviously, I suppose if you're if you are a corporate entity on the call, you provide communication services, and you're looking at this regulation, which is going to come down the line very soon with an implementation date of 2 years from the time of agreement. But you're looking at it going, well, how am I going to really tell the difference between a Spanish police or a Slovakian competition authority? There is in the regulation the concept of what they call a Central European exchange system, which will allow the regulator or law enforcement agency in the country to upload the order directly to that, and then the service provider basically obtains it. So it's almost like a mailbox in between the law enforcement agency and the service provider. And that is, I suppose, that's the thinking on that is not yet finalized, but just so that you're aware of that, because that for smaller service providers, that will be a massive concern in validating the production and preservation orders. There are, again, provisions for the central authority in this particular role. So obviously, if there's a concern in receiving any of these orders when they do go live, the central authority will be available. And then I suppose another key role which the central authority has is the grounds for refusal. So Fiona spoke briefly at the earlier part of this presentation about how some of these production orders or warrants for electronic evidence can be unnecessarily large or disproportionate to the stated aims of the criminal investigation. And so the central authorities of each member state will have a role in I suppose, refusing to actually enforce them if they believe that there's a manifest breach of fundamental rights under Article 6 of the TEU and the EU Charter. And so some of those kind of fundamental rights which are expressly referenced in the regulation are double jeopardy, the nebis in idem situation, or if the central authority understands that there's going to be a parallel investigation in another member state. And then I suppose the meat really, in terms of grounds of refusal, is really based in privilege. So if the investigation is seeking legal professional privilege to information, or journalistic privileged, or parliamentary or diplomatic privileged material, there are obviously massive concerns for that. And recital 37 in the regulation leaves it to basically domestic law to establish grounds for refusal on those bases. And I think another particular area which is of growing concern, especially we've seen it in the US with the reversal of the Roe and Wade decision, is healthcare data. So are there member states or investigative agencies out there who are going to be investigating crimes which actually aren't crimes in Ireland, for example? So any of these types of sensitive or privileged material, there will be opportunity to refuse to actually comply with the order. And then I suppose just kind of looking at it from if you're a regulator on the call, and you're going to look for this data, and you've seen what happens with, the Consumer and Competition Protection, the Competition and Consumer Protection Authority, rather, when you go and actually obtain massive amounts of data, I think it's really important at this point in time to start thinking about integrated data management systems, because during the course of your investigation, and Garda Síochána experienced this the whole time, if you're obtaining tablets and phones and hard evidence, physical evidence, and evidence from service providers on the cloud, you're going to have a system which actually integrates all of this data in order to make sure that you're establishing what your investigation is giving you in terms of evidence. And I personally feel it's a situation where regulators should be thinking about how to staff that appropriately, and whether or not it's something to invest in from the data management perspective, because wasting human resources trawling through terabytes of data is really something which is not great for either the limited resources of public agencies or the staff involved in that particular agency. And there have been recent cases in Irish courts where prosecutions have failed due to data not being managed properly. And then the second issue as a regulator, and the obligations which are laid out in this regulation, is data security. And so That's particularly expressly mentioned in the regulation. How are you going to manage data security with electronic evidence? And that's, I suppose, concepts to be thinking about with your IT unit in terms of, encryption and limited access and storage, and whether or not you're going to store on premises, on data services, or in the cloud. There's this particular area of electronic evidence is being discussed in loads of different areas. Shane, I don't know if you'd like me to kind of go on to that particular part of what's happening internationally.
Yeah, I think it'd be helpful just to outline, I suppose, just some of the non-EU legal instruments, maybe, Aisling.
Yeah. So I think when we're looking for guidance about these particular issues, it's really helpful to look first at, as I said, the Budapest Convention on Cybercrime, because their second additional protocol of last year has all of these concepts expressly set out. And there's been a very helpful paper that just this week published by an organization called the Cross-Border Data Forum. On what is data. So for people kind of coming at this as a electronic evidence, this is a new area for them, or it's something that they may not be completely familiar with. There's a great paper which has just been issued this week, and we can drop the link in the follow-up email. So those two particular international instruments, and I should say Ireland is actually the only EU member state and the only member of the Council of Europe which has not ratified the Budapest Convention yet, which is somewhat difficult. When I talk to international lawyers, they find that very difficult to understand why we haven't actually ratified that convention and the second additional protocol. But I do feel that that's going to move along once this e-evidence regulation is in place. And then the second kind of big issue, which I'd like to draw your attention to, is just last month in December 2022, the OECD, which is a multinational, multilateral non-governmental agency, passed a declaration on trusted government access to personal data held by private sector entities. And that's a soft law kind of instrument, but it sets out 8 principles where OECD members have agreed to abide by when actually implementing legislation dealing with electronic evidence and by government access to electronic evidence or data. And the key principle, which I would kind of pull out of those 8, is legitimate aims. So we have agreed, Ireland as a member of the OECD has agreed to baking in these concepts of necessity and proportionality to any type of law. And we can speak a little bit further about those. The other thing which is happening as we speak in Vienna is the draft UN Cybercrime Treaty, which has a whole chapter dedicated to lawful access to data. And then the last thing that I wanted to kind of flag is the European Electronic Communication Code, which sounds like it would not trouble a criminal investigator or a regulator, but actually that has fundamentally changed EU member states' surveillance laws. And so it has brought into scope the possibility of changing surveillance laws in order to incorporate not just traditional telephone calls, but VoIP calls, anything basically over the internet where person is communicating. So again, it's kind of like the law is catching up with the reality. And that European Electronic Communications Code, there's a statutory instrument which has transposed the Irish version of it. That's SI 444 2022, which doesn't change the surveillance laws in Ireland, but the surveillance laws in Germany and in France have changed as a result of that. And so if you are a communication service provider, by the end of this year, you may be receiving orders from German law enforcement for surveillance capabilities. And that's important, obviously, in Ireland, because Ireland has not updated its interception laws specifically. They have, there is a Surveillance Act of 2019, I believe off the top of my head, but they have not updated their intercept laws. And so that's important. So I think, Shane, there are some of the kind of top of mind international legal instruments which are discussing these issues, and happy to discuss further.
Thanks very much, Aisling, and you've fitted a huge amount in there to 20 minutes in terms of the landscape. So thank you for that. Can I just ask, Aisling, just again to bring it back domestically, and I know there's been a number of there's been a couple of recent Court of Appeal decisions. In you touched on journalistic privilege. I think there's the Corcoran case, which is currently before the Supreme Court, and the other case, I suppose, is the Quirk murder trial that people will be aware of. And again, that judgment that's been heard by the Supreme Court, and judgment has been reserved in that. And I think to bring that back to what you touched on in terms of the core concepts of necessity and proportionality in a production order, what to do, I suppose, whilst we're awaiting the decisions of the Supreme Court in respect to those, what are the, I suppose, key takeaways from the Court of Appeal decisions in respect of ensuring that those proportionality and necessity are enshrined in a production order?
Yeah, I mean, they're fascinating cases, Shane. And if you take them in the actual order in which the judgments were handed down, Quirk was obviously the murder case, which was an incredibly lengthy murder, where there was a search warrant which was issued by the district court for the Gardaí to go in and obtain evidence from the accused's house. And without including it, basically, there was no reference on the search warrant to any computer or electronic device, but they obtained those devices and they used the evidence really primarily relating to the person's search history and their internet searches on decomposition and those types of gruesome searches at trial as circumstantial evidence. Now, the Court of Appeal judgment basically asks whether or not the omission of any type of reference to computer or electronic evidence from the search warrant would either deprive the district court of jurisdiction to issue the warrant, or would it make it invalid? And the Court of Appeal judgment in Quirk basically kind of tells us as practitioners in this area is that, yes, there's no requirement that the information or search warrant must contain a definitive list of all evidence to be seized, but a failure to incorporate reference to the computers in the body of the warrant may be categorized as inadvertence. And while it would not invalidate the warrant in this case, it basically would open the door to challenge. And so I think if I was advising regulators or investigators on this call, I would say be very sure to include reference to any type of electronic devices in a search warrant that you're going into. And really, if you compare that with Corcoran, which is really about, at the heart of it, it's about journalistic privilege. The warrant in Corcoran was much more sophisticated and did include, obviously, the mobile phone, which was at the heart of that prosecution. But Corcoran, I suppose, Corcoran tells you as an investigator or a regulator that you are under an obligation to make full disclosure in order that the district court judge may properly balance the competing rights of the public interest and the rights of the journalists. And so I think it would two things. You know, as I said, with work, make sure that you incorporate any reference to electronic devices in your warrant, because I don't think, in light of Corcoran, that judgment will hold much water going forward. Corcoran is basically telling you that if you do not appraise the district court judge of the full facts, then you're open to challenge.
And I think that's a follow-on from what you and Fiona referred to, the CRH and CCPC, which is, again, and we often come across this, that, you know, we advise corporates and they get a warrant in, and we do manage to obtain the information sometimes from law enforcement, and the information will include a vast array of information that wasn't included on the warrant itself. And I think that was the case in CRH, where Mr. Justice McMenamin, now retired from the Supreme Court, he was critical in terms of that the information included a lot of information which the warrant didn't. So I think as you said, Aisling, full disclosure is and again, authorised officers on this call will be aware when they go into judges' chambers, often they are quizzed by the district court judge as to you know, their reasonable belief, and again, as you said, the journalistic privilege aspect, there must be full disclosure in respect to such matters.
And I would just add to that, Shane, is that it's not just journalistic privilege, which is kind of really a very niche area. There's small amounts of criminal investigations. It's any investigation which would involve a law firm as well. So be very careful when you're completing warrants for law firms.
Yeah. Great. Thank you, Aisling, for that. I might turn to, we're 11:45 now. I'm conscious we want to get lots of questions coming in, and feel free to add more to the Q&A function below. So if I start just in the order they've come in, there's a question here. What must be included on a warrant or production order for it to be valid? I can take this. It's a good question. It's quite a broad question. I suppose twofold, really. Firstly, as Fiona said at the outset, the starting point is for the investigator to look at the relevant statutory provision which permits the issuance of the search warrant. So make sure you obviously apply under the correct provision, because that will tell you what proofs are required, because the proofs are different in respect of the whatever the search warrant is. So you will generally have the provision that there are reasonable grounds for believing that a particular criminal offence had been committed. But as Fiona touched on, some provisions will outline that the proofs are that, for example, that there are reasonable grounds for believing that the material sought is going to be of substantial value to the offence as well. So you have to be very careful in terms of ensuring that the proofs obviously are met. In terms then, secondly, in terms of, I suppose, the question maybe in terms of the content, and again, as we said, as Fiona said earlier, in terms of pushback of orders, it's the key elements. It's ensuring that the act which authorises the warrant, that's obviously on the warrant or order. Secondly, if you're in receipt of one of these orders, ensuring that the actual criminal offence that Aisling has alluded to in respect of the EU context and a minimum threshold of 3 years. But again, just because an investigator is investigating a criminal offence under their powers, that doesn't mean that the search warrant will allow for that a search warrant can be issued in respect to that particular offence. Often warrants are only allowed in respect of particular offences. In the, I suppose, traditional criminal context, it's sometimes the serious offence, scheduled offences, meaning minimum of 5 years is often used. But again, for a lot of regulatory crime, it's down to the particular offences under the Act. So it's very important if you're looking at these warrants, to ensure that in fact the warrant does hold water and it does actually apply to the offences being investigated. Again, as Fiona said, ensure that the warrant is signed by a district court judge, ensure that the guard is of the particular rank required to apply for the warrant, and ensure that there's a time limit obviously on the warrant. And of course, very important that the time limit hasn't expired. So if the time limit has expired before you get the warrant, obviously that's you just send that back, of course. So I think that's kind of, I suppose, the main areas in terms of looking at. Sorry, the next question, maybe Fiona, you want to take this. Will an error on a warrant result in the warrant being declared invalid?
Short answer, Shane, is no, not necessarily. From the 90s onwards in Ireland, there was quite a high bar for invalid warrants, and the exclusionary rule. But the decision JC that I referenced earlier, since then the courts will engage in more of a balancing exercise, more analysis as to whether the investigator acted in good faith, and if the breach of the constitutional rights of the property being searched, or the person who's the subject of the search warrant or production order, if the breach is inadvertent, I think the courts will certainly be more open to permitting the evidence obtained on foot of that. I think again, just the key words of being specific, focused, organised when you're thinking about and planning for and obtaining a search warrant, that will be of assistance here to make sure that you're not faced with a case being thrown out ultimately because of an invalid search warrant.
Great, and I think there's, well, obviously it goes without saying that search warrants are subject to challenge, and I think the seminal case is probably the People DPP and Talent in terms of the power of obviously of review of the district court judge, forming the agreeing with the application that there's reasonable belief that an offence had been committed. So just to point that out. I'm sorry, I meant to say, I think Aisling said she'd include just hyperlinks to some of the matters she referred to, and we'll also include some hyperlinks on the cases, Corcoran and Quirk and CPCC after the seminar webinar. I think, Aisling, there's a number of questions for you then, specifically, if you don't mind.
Yeah.
So first, will there be a similar arrangement for UK, including Northern Ireland in particular?
So obviously, the UK and Northern Ireland, no longer being part of the EU, are not going to be bound by this EU regulation. Their Investigatory Powers Act is basically the legislation that they use to serve on service providers outside the UK and NI, all of the UK jurisdictions. And then they've also agreed a Cloud Act agreement with the US. And so that's basically their equivalent of this EU regulation with US providers. So any type of UK law enforcement where they're looking for data or electronic evidence from US based companies, they'll go through the Cloud Act. There's a couple of other questions, Shane.
There is, yes. The next one is, how is production order enforced on a non-EU entity?
So under this new regulation, it won't matter if it's a non-EU entity. So you could have an Indian service provider providing services in the EU. And as I said, the jurisdictional hook is that they offer services. At the moment, if you're an EU law enforcement agency, you would have to go to an MLAT to India to get that data at the moment. So it's really about, you have to establish that the service provider offers services in the EU.
Okay, and an easy one for you here, Aisling. In your view, is the EU inclined to place privacy rights on a pedestal that is far too high when compared to competing rights?
Well, if you had asked me that as a prosecutor, I would have said yes. And now that I advise Microsoft, I would say no. I mean, I think you have to ultimately come down to what would you like to have happen to your personal data on your phone if the police knocked on your door. So I think it's actually, there has to be a balance there, because there's a power to obtain not just your data on your phone, but other people's data, your children's data or other people's data. So privacy rights are key to it.
Is it possible to dictate the format of how the information is produced? Example, soft versus hard copy encryption, specialist software.
This is an interesting question. So if you are a regulator or law enforcement agency looking for data, you want the service provider to give it to you in the format that they have, because otherwise there's provenance issues if you seek to issue it at trial. So at the moment, there's no ability for law enforcement agents to compel the format of the evidence, and that's not going to be changed in the regulation.
And perhaps we might just leave it at this then. How will these new provisions be affected by the Retention of Data Act?
I suppose it's a pool of law which swims alongside this, because obviously the data can only be accessed by law enforcement in a period of which it's legally retained. And so it's kind of a chicken and the egg situation. If the retention of data, the Communications Retention of Data Amendment Act is actually commenced, then that will impact the amount of data that law enforcement can obtain. And so it is the retention of data needs to be established properly, because it will have an impact on what law enforcement can obtain. But at the moment, that act hasn't been commenced.
Yeah. Okay. Look, we're going to look at any questions that we didn't get to, and apologies for that. We've got through a few there, and obviously feel free to drop us an email or a call to meet with Fiona, and we'll go through them with Aisling as well. All that remains is for me to thank everyone for attending this morning, and thank you in particular to Fiona and Aisling as well for a really insightful summary of this ever-changing landscape. I think a survey is going to pop up at the automatically on the screen when this ends. So we just be grateful if you could just take a minute just to fill that out, and future topics suggestions as well. Thanks everyone.